The last case on the docket is Cobb, O'Donnell, and Dillard versus Suncoast Primate Sanctuary. Mr. Biasotti, how are you?
Great. Good morning, Rob. And may it please the court. My name is Robert Biasotti, and I represent the appellants, Cobb, O'Donnell, and Dillard. Let me start this case by reading something from the transcript. This case is about the rule of law. Do statutes have a meaning? And will they be applied, or will a statute simply be disregarded because we want it to? That's Mr. Haas's first two sentences in his opening statement in this case. And this is all about the statutes that apply to this case. And before I go on,
Go ahead. Sorry.
5 minutes for rebuttal, and I forgot to introduce my partner and best friend, Brandon Vesley. Okay.
Yes, Mr. Biasotti, before we get into the statutes, I know that there was a motion to dismiss for lack of jurisdiction filed while the appeal was pending. I know that we denied it. I'm still having a hard time understanding why we have jurisdiction over Mr. Cobb's appeal of the partial final judgment, when it is clearly intertwined, certainly with count 4, which remains outstanding, and also with the count request for an accounting.
Well, you certainly have it's a mandatory jurisdiction for the other two appellants. And we argued, and I think, at least up until now, we prevailed, that it is so intertwined with the other appeal, which is a mandatory appeal for the other two appellants. So do you have jurisdiction? Yes, you do. It's a partial final judgment. It was done on a deck action, and the case essentially went away on that. And the reason is because before you reconsider or do counts 2, 3, and 4, or other parts of the thing, you need to figure out who is the real board of directors of this entity.
So your argument would be anytime a preliminary question of law is decided, it's immediately appealable, even if it is, as the rule says, even if it is interdependent with, not dependent on, not that these other claims, flow from it, whatever, but interdependent with claims that still remain outstanding.
In this case, yes, because the other claims make no sense if John Cobb is a member of the board of directors. And he is, by the way.
Was this resolve the case as to O'Donnell and Dillard?
Yes, absolutely. Why? Why do you ask? Why is that?
Well, tell me.
Okay, I will. First, let me say that I said this in the brief, and the appellees took exception to it. This case involves two competing entities seeking to find out who were the true board of directors.
Well, there's not entities.
They are entities.
There's one entity. There's the corporation, the foundation. And you have, what you have is a dueling.
Two people saying I'm the entity or you're the entity.
No, there's only one entity. I have dueling boards of directors. So the dispute is who is the authorized board of directors.
Correct. That's correct.
Which leads me to another question.
Yes.
I can disregard all the stuff in the briefs about the members. There are no members.
I think I stipulated that as much as I possibly
The
could.
question is, what do the articles of incorporation provide for replacing a outgoing director?
They don't. They don't. The statutes provide for that.
Okay.
And there is no question that one of the board of directors, one of the original board of directors, resigned in writing in line with section 6170807, was done in 2007, and she was not on the board of directors at any time after that. Simple as that. This case could have been decided in 10 minutes. It's a declaratory judgment.
Except there's that email, which suggested at some point in the interim, she returned to the board of directors. Even if all of the formalities weren't necessarily filed, why is that email, and actually we don't know if they're filed. I mean, for all we know, there is a writing somewhere that.
Well, it's not in this record, certainly.
Right, right.
And that email is not even complete, and that was an objection. We didn't make it on an appeal, but it's an incorrect email, not to anybody. It just says John. And when John Cobb was asked under oath at trial, did you resign? No. Did you ever sign anything resigning from directors? No.
Oh, I don't mean his email resigning. I mean his email basically ratifying Holly as being a member of the board.
Well, first of all, let's assume that's true. That doesn't follow the statute. The statute for how you replace somebody is 617-0809.
The remaining directors somehow or another under the statute, correct?
Yes. There were 3 original directors. There were, for many, many years, 2 directors. Does that follow the statutes? No.
Well, it doesn't say when you have to fill the vacancy, does it?
It's true, but it does tell you how to fill the vacancy, and that's set out in the statute. In the plain language of the statute, reads 617-0809, board vacancy. Any vacancy on the board may be filled by an affirmative vote of the majority of the remaining directors, even though the remaining directors constitute less than a quorum. Or if it's not so filled, or if there are no directors, you do it by application by any person to the circuit court registered where the office of the corporation is located. This case isn't that. That's not what happened.
This case is a corporation that doesn't know how to do corporate governance.
Your Honor, this is a non-profit corporation that's been in existence in northern Pinellas County for 50 years. Started in 2003. It's a zoo. I've never been there. Maybe some of you have been. It's been there for 50 years. It was the May Noel Zoo. It became a foundation. It was run by her granddaughter, who has run this from day to day to day. And you're going to hear the words rogue board. You want to talk about a rogue board? The rogue board are the people who took over this corporation without following any statutes whatsoever. They did not follow filling the board vacancy, removal of directors, members generally, which, by the way, we waived. And should that have been done? Yes. Should there have been bylaws? Absolutely. Should have been done. Was there an organizational meeting of the directors in 2003? No. No evidence to support any of that. Was this done? You know, they're basically, and I've done a lot of research on not-for-profits in Florida and around the United States. They basically fall into, you know, Red Cross, the Catholic Church. Those are not-for-profit entities. What else? Boards of co-ops. Those are members. You buy a co-op, you're a member. Okay? Those are the cases that exist. This is a small zoo that's been running for 50 years, that from 2016, when this rogue board took over this.
And if I may, Mr. Giussano, I have trouble with you saying a rogue board. If you look at what's before us here, as I review the statute, as I review what was presented to the court, the portion of the statute would deal with nonprofit, and I'm glad you mentioned nonprofit, as opposed to
217, not 207, correct.
I understand that. And this is the portion that, at least in my review, says, quote, any vacancy occurring on the board of directors may be filled by the affirmative vote of the majority of the remaining directors. Based on this record, it appears that Holly had resigned and then she was reappointed. This is what's in this record. And the trial court had all that before it in order to make the appropriate declaration. The other two decided to appoint her. And so based on this, the court had before them, can we really say right now that there's and you mentioned about it, bogus court, and you have to look at the statute itself and see
Okay.
the sequence that occurred. Help me out. Why is this a problem?
We spent some time in our brief researching the statute. And what kind of makes this important for me is that all of the statutes we're talking about changed in 2009. In 2009, Section 617-01401, it used to say, as used in this act, unless the context otherwise requires the term, and then it goes on to explain articles of incorporation, board of directors, bylaws, corporation not-for-profit, members, person, including an individual and an entity. Those are definitions in this statute. Pre-2009, a trial court could look at unless the context otherwise requires. This legislature, the legislature of Florida, deleted those words after 2009. Now the statute, since 2009, says, as used in this chapter, the term, colon, and it defines articles of incorporation, board of directors, bylaws, etc. Now, to answer your question, I identified the final, partial final judgment that's on appeal, and I listed them by paragraphs, even though they're not numbered. Paragraphs 9 and 10 use the terms like de facto. Let me get the final judgment. Although Christy Holly resigned as a member, blah, 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 the evidence contained in the record strongly suggests that John Cobb and Nancy Nagel de facto reappointed Ms. Holly. I'm sorry, that's not what the statute says. There's a way to reappoint somebody by an affirmative vote of the members, and you put that in a board minutes or something in writing.
So that's the argument. That's why the email, the April 5th, 2016 email.
Does not constitute that.
Okay, so is this, you're saying basically that this change in the definition section in 2009 is some sort of best evidence requirement?
No, I'm saying that it takes out the judge's authority and ability to consider extrinsic evidence to find somebody is de facto appointed. And they found that that she was de facto, Christy Holly was de facto appointed, and John Cobb was de facto.
Basically, in fact, that she was in fact reappointed, not.
Well,
Why
was she not reappointed?
Well, according to Mr. Cobb's own statement in the April 5th, 2016 email, she was a member of the board at that time. The board consists of Ms. Holly, Ms. Nagel, and Mr. Cobb.
There is lots and lots of extrinsic evidence in the 12,000 page records of what happened in the county court, what happened in the circuit court, and the 60 exhibits that they put in. It does not comply with 617, 0809, and 0808.
So despite what might be a concession by Mr. Cobb, your position would be we should have meeting minutes or some other corporate record that reflects.
Would be nice.
that she was reappointed.
Would be nice.
So his concession is not enough.
No. It certainly doesn't follow the statute. I mean, the statute makes pretty clear.
But how could we ignore that concession, Mr. Biassatti?
Well, first of all, it certainly wasn't a meeting, and it wasn't a concession by two people, the two people on the board.
Well, it's by the one who's challenging it right now, so,
Oh, we're the ones who are challenging.
Right.
They brought the complaint against us.
right, Mr. Cobb is challenging that Holly was a member of the board. Nagel is
Right.
not. So it's an email among the three of them, isn't it?
No, I mean, I don't think she was, if you go back to the record where that email was entered into
From
evidence.
John Cobb to C. Holly and Nagel.
No, I'm sorry. I have to see if I have the transcript site, but you should talk about that when it went into evidence. Because there was a whole part of things saying, it's not a full page, it's part of a page. And when they asked John Cobb, do you remember this? He says, I don't know. I'd like to see the full page. And then it actually got into evidence as a statement against a party opponent. And that's the problem with this case, because it's supposed to be against two competing people who should be at the same level. But because the three people who were not the board of directors, Mr. Jacquet was never a member of the board of directors until they appointed him. He was never even on the property, according to his own testimony, after June 26, 2016. He was never on the property after that. So who ran this property for 50 years? Debbie Cobb and her grandmother may know. Now,
To be Asadi, you're into your rebuttal time, so use your time as you wish.
Judge, I will take your advice if it's advice, and I will reserve my 5 minutes.
Very well, thank you. Mr. Haas.
Good morning. May it please the court, I'm Lee Haas of Haas and Castillo, and I represent the Appellees. This appeal has absolutely no merit because appellants have abandoned the singular argument that they maintained for 6 years in the trial court that I fought in front of multiple judges. And that singular argument, that they were the proper board of directors of the corporation elected by its members, whom they've now, well, they said they didn't concede it, they didn't challenge it.
Well, for our purposes, it might as well be a concession, right? Because we can't revisit it.
Well, you know, I only do some appellate work in my 40 years. But I don't understand the difference between a concession and failing to challenge something. And I read the recent opinion that Judge Kuzama authored in the 34th Street case that says you've abandoned the argument when you abandoned it in your initial brief. So they've abandoned the argument that there were no members. That was their whole argument the entire 6 years of the trial court case. If you read the amended verified counterclaim that I'll get to in a little bit, their argument was, oh, we were somehow informally members, notwithstanding the failure to comply with section 617-0601-1A. That was their argument for 6 years. And then they come along in this appeal and say, oh, we're not even going to try to challenge that. So in my mind, it's a concession. Maybe it's not a concession. Maybe it's just an abandonment. And it's for this court to decide if there's some distinction between an abandonment or a concession, because I don't see the difference.
So we come back to the key issue. Who was on the board and how do you replace?
That's really simple. That's really simple. So there is no disputing, no one disputes that Ms. Holly resigned from the board, right, in 2007. Nobody disputes that. So the question, there are two questions, I think, in your question, Judge. Number one, how does Ms. Holly get back on the board? And number two, how does Mr. Cobb go off the board so that Mr. Peltier can take his place? Those are, I think those are subsumed in the question you've posed. Well, again, and I'm going to not use the word nonprofit because my tax law friends would shoot me. Nonprofit is a tax term under the Internal Revenue Code. Not for profit is a Chapter 617 entity. Often they're the same, okay? Not-for-profit corporations are often nonprofit entities recognized by the IRS, but not always the same. And there are obviously nonprofit entities, maybe certain types of trust or charitable foundations, that are not-for-profit corporations. So 617 is the applicable statute, and it says, hey, the affirmative vote of a majority, and council says, oh, well, they didn't comply with the statute. They can't do this. Well, I've read the statute multiple times, and there is nothing that says, well, you must adopt a resolution and it must bear the corporate seal to show that there was an affirmative vote by the remaining members of the board, because they understand there are no members. Remember, they've conceded that. So we're not governed by 617-0809 sub 2. We're governed by 617-0809 sub 1, right? It says, any vacancy occurring on the board of directors may be filled by the affirmative vote of the majority of the remaining directors. Now,
But we have two directors who for a long period of time don't fill that vacancy.
right, there's no question. But the seat still existed, because remember, under both federal law, nonprofits, and under state law, chapter 617, a not-for-profit corporation, unlike a for-profit corporation that can have as little as one director, a not-for-profit corporation under Florida law must have 3, no less than 3. So what you have is a situation where you have a vacant seat. By law, the corporation can have no less than 3 directors. Otherwise, the corporation would have been dissolved, and it literally could have been dissolved by the Attorney General, Secretary of State, taking legal action. You know, the statute provides, the chapter provides for an action by the state. Didn't happen. So we adopt, and in fact, there was testimony, it's in the record by the expert witness about this concept of not-for-profit corporate governance, that you have this, essentially this presumption that you have this empty board seat that's there for these period of years. And then there is the act of the 2 remaining directors, Ms. Nagel and Mr. Cobb, to reappoint Ms. Holly to the board.
Before they do the reappointment, if they did anything in the interim, would that be ultra vires?
No, it would not, because there's the concept of ratification that's contained within chapter 617 as well.
So once appointing the third, all 3 of them could ratify what the other 2 had previously done.
Exactly, exactly. And there's law to that effect. I mean, I don't have the case citations for you, but I believe even the statute itself, one of the sections within 617, I believe, addresses that concept. Just like, for instance, I'll give you another example, like administrative dissolution, right? Technically, a corporation isn't allowed to act when it's administratively dissolved, but the reinstatement of the corporation, paying the penalty fees and being reinstated, is a ratification of its prior acts that were done while it was not. So again, I believe the same would apply here. So to Judge Rothstein-Yoakum's point, we have multiple acts, and it isn't just the electronic articles of annual report, the electronic annual report signed by John Cobb saying that Ms. Holly is back on the board. Not only do we have the email where he puts it in all caps, this is who the board is, we have his testimony. I mentioned it. I gave the record reference in my answer brief where he testifies that she's the president of the corporation. How could she be the president of the corporation if she's not on the board? She couldn't be, because again, there are no members. There are only the directors of the corporation. That's the only way it happens. So, I want to show the court something real quickly. And we kind of skipped over these. I made this years ago for the trial judge, made it real simple, you know, no bylaws, and I recited to 617-0601-1A. Here.
Here it is.
Have a copy for you.
Thank you.
Yeah. Mr. Mongeluzzi had a copy too.
It's not in the record.
It might be somewhere.
Tell us whether it is or not.
I don't know. It might be. buried somewhere in what was given to Judge Meyer.
I think I have seen that, something like that.
Okay.
I can't remember. That's an extensive record. I've seen something buried, I can't tell you where that was.
Okay. It would have been a demonstrative, is what it was, or
But it was made reference to it. I've seen that.
Okay. And so the issue is again, and we can kind of gloss over it now because, you know, I was arguing there were no bylaws. The Articles of Incorporation didn't have the required language, so you had to go to bylaws. They admitted there were no bylaws. Well, we can kind of skip over all of that because they've not only admitted there were no bylaws, they've also gone ahead and admitted there were no members, which is what I couldn't get them to admit for 6 years. Well, now they have no standing because who are they? Who are these people? Who is Sandra Dillard in relation to the corporation? Who is Charles O'Donnell in relation to the corporation? They're squatters. I mean, it's like making the argument that the owners didn't cut the grass, so I'm entitled to move in and take possession of the house. Except in this case, the corporate entity, and Judge LaRose, you hit it on the head. This is not two competing entities. There's one entity, corporation. There's groups of people who are claiming to be boards of directors, but there's only one entity. And what they're doing is they're saying, we're the entity that has the right to take over this house because you didn't cut the grass. Because you didn't adopt bylaws, we have this God-given right to just step in and take control of this corporation. Except again, you have no legal relationship to it whatsoever. So where does your right come from? It has to come from a statute. They don't put any evidence of any statutes. All they do is they try to say, oh, well, you didn't do this, you didn't do that. So again, and I need to go back because I only addressed part of your statement. That's how Ms. Holly got back onto the board was, again, you have proof of the affirmative vote. Yes, I will agree with the court. There is no nice, fancy resolution, you know, be it resolved with a little embossed seal like we used to use years and years ago. No, there's not. But there's all that evidence, the electronic annual report, the email by Mr. Cobb, Mr. Cobb's testimony. There was all of that. Now, the other part of your question that I need to address is the idea of, well, how does Mr. Cobb get replaced on the board by Mr. Peltier? And again, the statute doesn't say, other than the must be in writing, we have Mr. Cobb's acknowledgement that he had resigned from the board. We also have, even if he hadn't resigned from the board, that this is, again, it's a 3-person board. 2 people is a majority of 3. 2 people on the 3 could vote to remove the one and replace him with another. There's no statute that says otherwise. The statute, in fact, authorizes that. So that's how Ms. Holly came back on the board, and that's how Mr. Cobb went off the board and was replaced by Mr. Peltier. Well,
Mr. Husband, you circling the, I know you have a short time.
I'm sorry.
Judge Johnson, you can mention to Mr. Rosado about this issue. Do we have jurisdiction?
Well,
If we're,
you're preaching to the choir.
because, and I realize we have this other case that we held in abeyance pending the outcome of this one. The fact that my reader, it appears to be it's all intertwined. Can we definitely say that this partial files limit is an end to litigation, that we could proceed?
It is an end to litigation for Ms. Dillard and Mr. O'Donnell because neither of them are named in the other counts. The issue of whether or not it's intertwined or whether or not, 9.110K would allow the court to exercise jurisdiction anyway. I think that's the right subsection I'm referring to. I think the court has, my bigger issue on the jurisdictional question, to the judge's point, was Ms. Dillard filed a pro se notice of appeal, okay? She's not an attorney. I'm not aware that a pro se person can file an appeal on behalf of other pro se people. Mr. O'Donnell never filed a timely notice of appeal. So in the sense of whether or not the court has jurisdiction, the court has chosen, despite my motion to dismiss on that issue. But I would submit that there is no jurisdiction of Mr. O'Donnell, but not because of the intertwined nature of the remaining counts. Mine is, failure to file a notice of appeal within 30 days is jurisdictional in that respect. Again, as to Ms. Dillard, clearly this would be a final order and there's nothing remaining to be addressed with her below. And again, I believe the court could exercise jurisdiction as to Mr. Cobb. And I've been on the other side of this where the court ruled against me, saying, no, these are too intertwined. We're dismissing your appeal. Wait till you win or lose on your other count, because it's not appealable under kind of the discretionary, I hate to use that word, but there's a discretionary, I think, under the one rule section. I believe, again, it's 9.110K, but I could be wrong in my subsection. Does that answer your question, Judge?
It does.
Okay. Let me be very quick, because I know I'm running out of time. I'm going to skip over the...
You have 6 minutes.
Oh, I have that much? Oh, great. Okay. I want to move on to their next argument that I wanted to attack. Not only, the 617-0601, but they made this argument that, well, we brought this derivative claim as a derivative board of directors claim. Well, there's just 2 problems with that. One is the facts, 2 is the law. First is the fact that if you look at the amended answer, affirmative defenses, and verified shareholder derivative counterclaims, which is document 296, the record reference is 3130 through 3178, they allege in paragraph 25 of their counterclaim, this is that thing, despite Cobb, Holly, and Nagel's failure to formally create membership, SPSF has informally granted membership and voting privileges, and they list themselves. And then they go on, and in paragraph 33, they allege defendants, counterplaintiffs have been members or trustees of SPSF since the inception of this dispute. Okay? Now, so to say, oh, we were just claiming it as a board, no, they were claiming it as members. But here's their bigger problem. The statute, section 617.07401, which was enacted in 2009 and has not changed to this day, says in subsection 1, a person may not commence a proceeding in the right of a domestic or foreign corporation unless the person was a member of the corporation when the transaction complained of occurred, or unless the person became a member through transfer by operation of law from one who was a member at that time. They've admitted they're not members. How could they bring a derivative action? They don't address that in the initial brief. They don't address it in the reply brief. I still don't know. What is their theory now that they've abandoned the argument that they made for 6 years? What is their theory that they could bring a derivative action if they're not members? These people are interlopers. They're squatters. They're not just rogue, because rogue implies that you were legitimate once and then you went off the reservation. No, these are imposters. These are